Assalamualaikum warahmatullahi wabarakatuh. This is part 2 for the Zoom recorded lecture for the topic occupier's liability. So in part 1, we have looked at the definition of occupiers. We also look at the two cases discussing about occupiers. The cases that we discussed actually, or the case of Witt and Ileken and then Sri Inai. So for this part of the lecture, we are going to focus on the definition of the word premises. So what is the meaning of the word premises here? So actually, this is a broad word. Okay, it has a very big or very broad interpretation. So premises here, it's not limited to only building or only specific building or specific structure. It will include land, okay, and all types of buildings as well as all types of structures. For example, bridges, walls, ladders, lift, and escalators, as well as vehicles. Okay, it includes all types of vehicle used for carrying persons. For example, ships, okay, aeroplanes, motor cars, trains. So it will include all those vehicle. So having said so, premises actually covers everything here. It covers land, building, structure, as well as vehicles. Okay, let's move further. Okay, and in regards to the topic of OL, okay, other than discussing the definition of premises, okay, definition of occupier, okay, the next important thing that we have to know is classes of entrance, categories or classification of entrance. So at common law, there are 4 types of entrance. Entrance here refers to people, okay, people that who enter into the premises. So as far as the classes of entrance are concerned, we have 4. The first one is contractual entrant. We also have invitee, we have licensee, as well as trespasser. So this is the categories of entrance. And this is from originate from common law. Okay, and in Malaysia, we follow actually this particular classification. We are going to discuss one by one. Okay, we start with contractual entrance. So even the word itself give you some hints. Entrance, okay, in connection with contract. So who are contractual entrants here? So basically, contractual entrance refers to those people who enter a building or premise under a contract. And usually, in order for them to be there, to occupy the premises, they pay. There's certain money payment. And usually it is under contract, money payment under contracts here. So what's the nature of duty owed, okay, by occupier towards contractual entrance here? And if we compare to all the 4 classes of people or entrants just now, for contractual entrance, they actually occupier owe the highest duty of care. Okay, what's the duty of care here? To ensure, okay, they have to make sure that premises are as safe, okay, for the purpose of the contract, as reasonable care and skill can make them. Okay, there's no excuse on the part of the occupier. Has to make sure that the premises are totally safe for that purpose. And we have also subcategory under this contractual entrant. We have 2 types, okay, two further types here, which is either main purpose entrant or ancillary purpose entrant. So what is main purpose entrant? Main purpose entrant refers to those who enter the premises to use the premises, which is to dwell in them. Okay, for example, to stay overnight. Okay, the most typical example is tenant or guest in a hotel. And we have the case of McLennan and Segar, reported in the year 1917, very old case here. Who was the plaintiff? Plaintiff was a guest in defendant's hotel, and one day a fire broke out. Okay, when the plaintiff was staying in the hotel, a fire broke out, and plaintiff suffered injury, so he was injured. Now he said he sued the hotel owner. And then defendant, okay, the hotel owner, they failed to ensure that the hotel was safe for habitation. Because why? There was no emergency way out, whereas all hotel must have emergency exit, emergency way out. So the court held that yes, the owners of the hotel were liable. So if you actually, another relevant case would be Sri Inai, the case that we discussed in the earlier part, okay, in the first part of our lecture, Sri Inai, because it's also main purpose entrant. Who are the main purpose entrant in Sri Inai? The students, okay, because they are the one who occupy the building. The building was converted into a hostel, okay, and the students were staying there. Now we go to ancillary purpose entrance. What's the meaning of the word ancillary? Ancillary means secondaries. Lesser importance compared to the main purpose entrant here. Okay, I mean in terms of why they enter into the premises. For example of ancillary purpose entrant, for example, a spectator at sports event, or even patron at a cinema or theater, or patient or at a private hospital. Because why? Okay, they go there not to dwell, okay, not to stay for overnight, for example. They just go there to for specific purpose, for specific duration of time. For example, to watch games, okay, to watch competition, okay, to watch whatever sporting event here. So in sporting event, okay, we have some qualification here, okay, condition. So duty of occupier to ensure that spectator safety is not absolute. Meaning here, even though it's very high duty, but the duty is not absolute. Because why? The occupier is imposed with the legal responsibility to use reasonable care. But at the same time, okay, he is not required to guard against every possible danger, because usually games or sport, they come with it inherent danger or risk. Okay, this is what happened in the case of Murray. This is common law. Murray and Haringey, Arena Limited, reported in year 1951 in All England report. What happened was that it involved ice hockey. Okay, we don't have ice hockey in Malaysia. So plaintiff was struck by a hockey puck. Hockey puck is a rubber disc used in ice hockey. I think the part, okay, of the hockey, okay, hockey stick. So while watching a hockey game, and then he tried to claim against the hockey owner, okay, but the court denied his claim against the owner of the hockey stadium, because this is something which is inherent and which is not really preventable. Okay, meaning that here you enter the premises with the risk. So that's basically the case of the explanation or discussion of ancillary purpose entrant. Now let's move to invitee. Okay, who are invitee? Who is invitee? So invitee, from the word invite, okay, is a person who enters the premises, okay, based on express or implied invitation of the occupier. So mean that here it is the occupier who invite the invitee. It's either expressly, I invite you, or maybe impliedly. That's not invitation, but then impliedly we know, oh, you are the invitee. You are being invited by the occupier in respect of a business, okay, of common interest to himself and the occupier. I mean that here they have something in common, mutual interest, common interest. In relation to business, okay, they're having business intention. And we also have subcategory for invitees here. We have either, invitees can either be classified as legally authorized entrants or business visitors. Legally authorized entrants specifically refers to those who enters the premises under the authority of law. For example, policemen, okay, firemen, meter readers. So they have this permission, okay, invitation by way of legal, okay, legally authorized. And another category is business visitors. So meaning that here with whom the occupier has mutual business interest. For example, customer at a supermarket, or customer at a restaurant, customer at a bank, or even motorist at petrol station, or even employee at his workplace. They are all categorized as business visitors, and they are all under invitee. Okay, that's the category of entrant. We have a look. Let's have a look at the case law. In the Moore and Dames, what happened? This is a very old case, 1866, 19th century case. Plaintiff, he was a gas fitter, but he's supposed to do maintenance for the gas. Okay, so he was doing some testing at certain gas fitting at Dependence Factory, and while doing his work, he fell through an unfenced opening. And there's a certain hole or opening here in one of the upper floors. So he wasn't aware of this unfenced opening, so he fell down. So he suffered injury, and he sued the factory owner. And the court held that yes, factory owner defendant was liable because, okay, the unfenced opening, okay, in the upper floor was an unusual danger, something which we don't expect, okay, that's opening, that's unfenced opening. And from this case, the court established this rule, okay, with regards to invitee and the obligation imposed with it. With respect to invitee, occupier shall take, this is the strong word, okay, shall take reasonable care, okay, to prevent damage from unusual danger, of which he refers to occupier. He knows or ought to know, supposed to know, okay, and of which the entrant does not know. So meaning that from this particular rule, we can extract a few rules actually from this rule. Okay, there are 4 requirements. So there are 4 requirements based on the rule, based on the judgment just now. First, okay, the danger must be unusual one. If the danger is usual, then we cannot apply the rule. I mean, there's no obligation on the part of the occupier. Okay, and then second, occupier knows or ought to know, presume to know of the danger. And then the third one, the danger is not known to the entrant. He is not aware of the danger. And then the fourth one, of course, the occupier has failed to take reasonable care to prevent damage from occurring. Occupier is supposed to put up notice or provide proper lighting or guarding or otherwise. I mean that here, all the four requirements must be fulfilled before liability can be established on the part of the occupier. And then because we were discussing the case at common law, okay, in the more just now was a common law case. So the question is the rule applicable in Malaysia? The answer is in affirmative, yes. Okay, it is applicable in Malaysia by virtue of this case, Lau, Tin Sai, and Yusof bin Muhammad. So I mean that yeah, the court applied the rule which is applicable at common law. And then the court also make it clear that out of the four requirements, okay, the first one is the most important. All the four requirements are important, but out of four, the first one is the most important one. Meaning that if the first one is not satisfied, then the other three, won't be relevant. No need to discuss further. Okay, let's have a look at the case of Lau, Tin Sai, and Yusof bin Muhammad. What happened in this case? This is an appeal case. The respondent was injured when his right foot was cut by the blade of a tractor belonging to the appellant. So appellant is the tractor owner. And then which had been hired out to plow the land belonging to one Mustafa. And then who was respondent here? Respondent was not an employee of the appellant, but actually he had been allowed to travel on the tractor. He was there actually, okay, and that's why he suffered injury. And the respondent obtained judgment in the High Court and appellant appeal. I mean that here they won the case at the High Court, but not appellant appeal against the decision of the High Court. And the court held that as far as the facts were concerned, there was no evidence, no proof to show that the tractor driver was guilty of a breach of a duty to take care. There must be an evidence to show there's a breach. Okay, and the court said that the rule in and the more and deems here is not applicable. Okay, could not apply in this case because why? Even assuming the respondent was an invitee, okay, he was not injured as a result of any dangerous condition of the land. This is something which is normal, usual. Okay, it's not unusual. You can expect that there is something which is dangerous. Okay, the moment you decide to be on that particular tractor. Okay, now we want to focus on the first requirement, which is unusual danger. What's the meaning? How do you interpret the word unusual danger? So basically, unusual is not usual, not usually found in a place or premise. So it's very subjective in nature. What is unusual? It will depend on first, who is the plaintiff, type of plaintiff, as well as nature of the place or premise. Different place will actually give rise or exposed to different risks or different danger. So meaning that here, what is unusual to one person, to this plaintiff, maybe this is quite usual to the other plaintiff, to another person here. And what is unusual at one time in one place may be usual at another time in another place. What is usual today may be not usual tomorrow. Okay, it depends. Time and also place, locality, location. So we have this case of London Graving Dock Company Limited and Horton, decision by House of Lords, reported in the year 1951. The court, House of Lords held that a gangway. What is a gangway? A gangway refers to a passage along either side of a ship's upper deck, like in the picture. Okay, here. So a gangway, actually, this is not unusual danger. Here, it is usual for stevedores because they are working on the ship, on board of ship. But it is, of course, it is unusual danger for another class of workmen, okay, or for members of the public generally. So to some people, okay, to the workers, so there are something which is usual. This gangway is usual. But for other people, for public at large, this is something which is unusual. And for local case, we have the case of Takun Tabari and Government of Sarawak, reported in 1996. Here, the deceased, okay, he was making some banking transactions in the premises of a public bank, okay, located in Miri, and suddenly inflammable gas escaped. So the gas got ignited and it caused series of explosions and fire. And the estate of the deceased, the representative was suing the bank, okay, and the court held that the bank was liable because why? Explosion was something which is unusual danger in a bank. So you don't expect to have this explosion, especially in Malaysia, okay, in a bank. When you go to the bank to do some transaction, if there is explosion, this is something which is unusual, rarely happen. And because why? Bank is usually believed to be a safe and secure place, at least no explosion. Maybe it's not safe from robbery, but it should be safe from explosion, like this. And then on the part of apportionment of liability, actually premises of the bank here, the building, okay, it was owned by a bank, but the gas was supplied by state government. So the trial judge actually apportioned 90% of liability to state government, okay, and 10% to the bank. And then there's also issue whether the bank should bear more responsibility because it was fixed at 10%. And the court held that the state government bore the heavier responsibility for the explosion and fire compared to the bank. Because why? They are the one who supply the gas. Okay, so state government bore 90% of the blame and the bank 10%. So that's the explanation here why the liability is is divided in such a way, is apportioned in such a way, okay, in such a figure. Okay, we stop here. We are done with the first two categories of entrance, okay, as far as our OL, okay, occupier liability topic is concerned. Okay, I stop here. Okay.